Hi, for today's upload, we'll pick up from part 3 of the Bar Q&A Remedial Law Sequenced Syllabus 2019. We're still under summons, 2016. Juan sued Roberto for specific performance. Roberto knew that Juan was going to file the case, so he went out of town and temporarily stayed in another city to avoid service of summons. Juan engaged the services of Sheriff Matinic to serve the summons, but when the latter went to the residence of Roberto, he was told by the caretaker thereof that his employer no longer resides at the house. The caretaker is a high school graduate and is the godson of Roberto. Believing the caretaker's story to be true, Sheriff Matinic left a copy of the summons and complaint with the caretaker. Was there a valid substituted service of summons? Discuss the requirements for a valid service of summons. No, there was no valid substituted service of summons. In an action strictly in personam, personal service on the defendant is the preferred mode of service, that is, by handing a copy of the summons to the defendant in person. If defendant for excusable reasons cannot be served with the summons within a reasonable period, then substituted service can be resorted to. While substituted service of summons is permitted, it is extraordinary in character and in derogation of the usual method of service. Hence, it must faithfully and strictly comply with the prescribed requirements and circumstances authorized by the rules. Compliance with the rules regarding the service of summons is as important as the issue of due process for the court to acquire jurisdiction. For the presumption of regularity in the performance of official duty to apply, the sheriff's return must show that serious efforts or attempts were exerted to personally serve the summons and that said efforts failed. These facts must be specifically narrated in the return. It must clearly show that the substituted service must be made on a person of suitable age and discretion living in the dwelling or residence of defendant. Otherwise, the return is flawed and the presumption cannot be availed of. The Supreme Court laid down the requirements as follows. 1. Impossibility of prompt personal service, that is, the party relying on substituted service or the sheriff must show that defendant cannot be served promptly, or there is impossibility of prompt service within a reasonable time. Reasonable time being so much time as is necessary under the circumstances for a reasonably prudent and diligent man to do conveniently what the contract or duty requires that should be done, having a regard for the rights and possibility of loss, if any, to the other party. Moreover, it must be indicated therein that the sheriff has made several attempts at personal service for at least 3 times on at least 2 different dates. Number 2, specific details in the return. That is, the sheriff must describe in the return of summons the facts and circumstances surrounding the attempted personal service. Number 3, substituted service effected on a person of suitable age and discretion residing at defendant's house or residence, or a competent person in charge of defendant's office or regular place of business. Maria Imelda and Manotok versus Court of Appeals, GR 130974. Sirsef filed with the RTC a complaint for the foreclosure of real estate mortgage against siblings Sisla and Charybdis, co-owners of the property and co-signatories to the mortgage deed. The siblings permanently reside in Athens, Greece. Sirsef tipped off Sheriff Pluto that Sisla is on a balikbayan and is billeted at the Century Plaza Hotel in Pasay City. Sheriff Pluto went to the hotel and personally served Sisla the summons, but the latter refused to receive summons for Charybdis as she was not authorized to do so. Sheriff Pluto requested Sisla for the email address and has number of Charybdis, which the latter readily gave. Sheriff Pluto, in his return of the summons, stated that summons for Sisla was served personally as shown by her signature on the receiving copy of the summons. Summons on Charybdis was served pursuant to the amendment of Rule 14. By facsimile transmittal of the summons and complaint on defendant's FAR number as evidenced by transmission, verification report automatically generated by the fax machine indicating that it was received by the fax number to which it was sent on the date and the time indicated therein. Sealed 60 days after the receipt of Sheriff Pluto's return, filed a motion to declare Charybdis in default, as Charybdis did not file any responsive pleading. Question: should the court declare Charybdis in default? Sisla seasonably filed her answer, setting forth therein as the defense that Charybdis had paid the mortgage debt. Letter B. On the premises that Charybdis was properly declared in default, what is the effect of Sisila's answer to the complaint? Answer to letter A. Question: no, the court should not declare Charybdis in default because there was no proper service of summons. Section 12, Rule 14 of the Rules of Court applies only to a foreign private juridical entity that is not registered in the Philippines and has no resident agent in the country, and not to individuals. AM number 1136 SC, March 15, 2011. The service of summons by facsimile under said rule is therefore defective. A foreclosure of real estate mortgage is a quasi-in rem action. Thus the court can render a judgment as long as it has jurisdiction over the rest and any of the modes of extraterritorial service of summons under Section 15 of Rule 14 is complied with prior to leave of court. There is, unfortunately, no showing in the problem that a prior leave of court was obtained before resorting to extraterritorial service of summons. Hence, the service of summons is defective. Answer to letter B. Assuming that Charybdis was properly declared in default, the court shall try the case against all the defendants upon the answer filed by Sisla and render judgment upon the evidence presented. Section 3, letter C, Rule 9, Rules of Court. 2013. Alfie Bravo filed with the Regional Trial Court of Caloocan a complaint for a sum of money against Charlie Delta. The claim is for $1.5 million. The complaint alleges that Charlie borrowed the amount from Alfie and duly executed a promissory note as evidence of the loan. Charlie's office secretary Esther received the summonses at Charlie's office. Charlie failed to file an answer within the required period, and Alfie moved to declare Charlie in default and to be allowed to present evidence ex parte. 10 days later, Charlie filed his verified answer raising the defense of full payment with interest. Was there proper and valid service of summons on Charlie? No, there is no showing that earnest efforts were exerted to personally serve the summons on the defendant before substituted service was resorted to. Hence, the service of summons was improper. In an action strictly in personam, like complaints for a sum of money, personal service on the defendant is the preferred mode of service, that is, by handing a copy of the summons to the defendant in person. If defendant, for excusable reasons, cannot be served with the summons within a reasonable period, then substituted service can be resorted to. That is from the previous case, Manotok versus Court of Appeals. Otherwise stated, it is only when the defendant cannot be served personally within a reasonable time that substituted service may be made. Impossibility of prompt service should be shown by stating the efforts made to find the defendant personally and the fact that such efforts failed. This statement should be made in the proof of service, Galura versus Math Agro Corporation. Alternative answer to the question above: yes, if earnest efforts were exerted to serve the summons in person, but the same proved futile, then substituted service through defendant's secretary is valid. In Gentle Supreme Philippines, Inc. versus Ricardo Consulta, GR 1831-82, the Supreme Court held that it is not necessary that the person in charge of the defendant's regular place of business be specifically authorized to receive the summons. It is enough that he appears to be in charge. Consequently, the substituted service of summons to the defendant's secretary in the office is valid. If declared in default, what can Charlie do to obtain relief? If Charlie is declared in default, he has the following remedies to it. 1. He may at any time after discovery of the default but before judgment file a motion under oath to set aside the order of default on the ground that his failure to answer was due to fraud, accident, mistake, or excusable neglect, and that he has a meritorious defense. Number 2, if judgment has already been rendered when he discovered the default, but before the same has become final and executory, he may file a motion for a new trial under Section 1, letter A of Rule 37. Number 3, if he discovered the default after the judgment has become final and executory, he may file a petition for relief under Section 2 of Rule 38. And number 4, he may also appeal from the judgment rendered against him as contrary to the evidence or to the law, even if no petition to set aside the order of default has been presented to him. BD Longspan Builders versus RS Ampelocchio Realty Development, GR 169919. Note, there are additional remedies to address judgment by default, like motion for reconsideration Rule 37, annulment of judgment Rule 47, and petition for certiorari Rule 65. Alternative answer. The court committed grave abuse of discretion when it declared the defending party in default despite the latter's filing of an answer. Thus, a petition for certiorari under Rule 65 is the proper remedy. In San Pedro Cineplex Properties versus Heirs of Manuel Hamada Enano, GR 190754, the Supreme Court held that where the answer is filed beyond the reglementary period but before the defendant is declared in default, and there is no showing that defendant intends to delay the case, the answer should be admitted. Thus, it was error to declare the defending party in default after the answer was filed. Syllabus versus Syllabus, GR 144568. After all, the defect in the service of summons was cured by Charlie's filing of a verified answer raising only the defense of full payment. The belated filing of verified answer amounts to voluntary submission to the jurisdiction of the court and waiver of any defect in the service of summons. Can summons may be served by mail? False. Rule 14 of the Rules of Court on Summons provided only for serving summons, A, to the defendant in person, or B, if this is not possible, within a reasonable time, then by substituted service in accordance with Section 7 thereof, or C, if any of the foregoing two ways is not possible, then with leave of court, by publication in accordance with the same rule. Alternative answer, true, but only in exterritorial service under Rule on Summons, Section 15, where service may be effected in any other manner the court may deem sufficient. Lani filed an action for partition and accounting in the Regional Trial Court of Manila against her sister Mary Rose, who is a resident of Singapore and is not found in the Philippines. Upon motion, the court ordered the publication of the summons for 3 weeks in a local tabloid, Bulgar. Linda, an OFW vacationing in the Philippines, saw the summons in Bulgar and brought a copy of the tabloid when she returned to Singapore. Linda showed the tabloid and the page containing the summons to Mary Rose, who said, "Yes, I know. My kumare Arita scanned and emailed the page of Bulgar to me." Did the court acquire jurisdiction over Mary Rose? Partition is an action quasi in rem. Summons by publication is proper when the defendant does not reside and is not found in the Philippines, provided that a copy of the summons and order of the court are sent by registered mail to the last known address of the defendant. Section 15, Rule 14. Publication of the notice in Bulgar, a newspaper of general circulation, satisfies the requirement of summons by publication. Perez versus Perez, GR 1453-68. What is the effect of absence of summons on the judgment rendered in the case? The effect of the absence of summons on a judgment would make the judgment null and void because the court would not have jurisdiction over the person of the defendant. But if the defendant voluntarily appeared before the court, his appearance is equivalent to the service of summons, Section 20, Rule 14. When additional defendant is impleaded in the action, is it necessary that summons be served upon him? Yes, summons must be served on an additional defendant impleaded in the action so that the court can acquire jurisdiction over him, unless he makes a voluntary appearance. Is summons required to be served upon defendant who was substituted for the deceased? No, a defendant who was substituted for the deceased need not be served with summons because it is the court which orders him as the legal representative of the deceased to appear and substitute the deceased, Section 16, Rule 3. A sued XX Corporation, XXC, a corporation organized under Philippine laws for specific performance when the latter failed to deliver T-shirts to the former as stipulated in their contract of sale. Summons was served on the corporation's cashier and director. Would you consider service of summons on either officer sufficient? Summons on a domestic corporation through its cashier and director are not valid under the present rules, Section 11, Rule 14. They have been removed from those who can be served with summons for a domestic corporation. Cashier was substituted by treasurer. 2004, summons was issued by the MMRTC and actually received on time by defendant from his wife at their residence. The sheriff earlier that day had delivered the summons to her at said residence because defendant was not home all the time. The sheriff's return of or proof of service filed with the court in sum states that the summons, with a touch copy of the complaint, was served on defendant at his residence through his wife, a person of suitable age and discretion, then residing therein. Defendant moved to dismiss on the ground that the court had no jurisdiction over his person, as there was no valid service of summons on him because the sheriff's return or proof of service does not show that the sheriff first made a genuine attempt to serve the summons on defendant personally before serving it through his wife. Is the motion to dismiss meritorious? What is the purpose of summons, and by whom may it be served? The motion to dismiss is not meritorious because the defendant actually received the summons on time from his wife. Service on the wife was sufficient. Buticano versus Chu. It is the duty of the court to look into the sufficiency of the service. The sheriff's negligence is not, or in not stating in his return that he first made a genuine effort to serve the summons on the defendant, should not prejudice the plaintiff. Mapa versus Court of Appeals. The purpose of the summons is to inform the defendant of the complaint filed against him and to enable the court to acquire jurisdiction over his person. It may be served by the sheriff or his deputy or any person authorized by the court. Tina Guerrero filed with the Regional Trial Court Binan Laguna a complaint for a sum of money amounting to $1 million against Carlos Coro. The complaint alleges, among others, that Carlos borrowed from Tina the said amount as evidenced by a promissory note signed by Carlos and his wife, jointly and severally. Carlos was served with summons which was received by Linda, his secretary. However, Carlos failed to file an answer to the complaint with the 15-day reglementary period. Hence, Tina filed with the court a motion to declare Carlos in default and to allow her to present evidence ex parte. 5 days thereafter, Carlos filed his verified answer to the complaint, denying under oath the genuineness and due execution of the promissory note and contending that he has fully paid his loan with interest at 12% per annum. Was the summons validly served on Carlos? The summons was not validly served on Carlos because it was served on his secretary, and the requirements for substituted service have not been followed, such as showing that efforts have been exerted to serve the same on Carlos and such attempt has failed despite due diligence. Manotok versus CA. Alternative answer, service of summons on Carlos was validly served upon him if the return will show that it was done through substituted service because the defendant cannot be served personally within a reasonable time, despite diligent efforts made to serve the summons personally. Linda, as secretary of defendant Carlos, must likewise be shown to be a competent person in charge of defendant's office where summons was served. Section 7, Rule 14. If you were the judge, will you grant Tina's motion to declare Carlos in default? If I were the judge, I will not grant Tina's motion to declare Carlos in default because summons was not properly served and anyway, a verified answer to the complaint had already been filed. Moreover, it is better to decide a case on the merits rather than on technicality. Alternative answer is yes. If it was shown that summons was validly served and that the motion to declare Carlos in default was duly furnished on Carlos, and after conducting a hearing on the same motion. Rule 15, Motions. Therese, alleging that she was resident of Lapu-Lapu City, filed a complaint for damages against Atlanta Bank before the RTC of Lapu-Lapu City, following the dishonor of a check she drew in favor of Shirley against her current account, which she maintained in the bank's local branch. The bank filed a motion to dismiss the complaint on the ground that it failed to state a cause of action, but it was denied. It thus filed an answer. In the course of the trial, Therese admitted that she was a U.S. citizen residing in Los Angeles, California, and that she was temporarily billeted at the Pescado Hotel in Lapu-Lapu City, drawing the bank to file another motion to dismiss. The time on the ground of improper venue, since Therese is not a resident of Lapu-Lapu City, Therese opposed the motion citing the omnibus motion rule on the motion. The bank's second motion to dismiss, which is grounded on improper venue, should be denied. The improper venue of an action is deemed waived by the bank filing an earlier motion to dismiss without raising improper venue as an issue, and more so when the bank filed an answer without raising improper venue as an issue after its first motion to dismiss was denied. Under the Omnibus Motion Rule, Rule 15, Section 8, Rules of Court, which governs the bank's motion to dismiss, such motion should include all objections then available. Otherwise, all objections not included shall be deemed waived. Although the improper venue became known only in the course of the trial, the same should not be allowed to obstruct or disturb the proceedings, since venue of civil actions is defined for the convenience of the parties, not jurisdictional. Alternative answer, the Omnibus Motion Rule should not apply because the improper venue became known and thus available only to the movant bank after the motion to dismiss were filed and resolved by the court and in the course of the trial of the case. In fairness to the defending bank, it should not be precluded by the Omnibus Motion Rule from raising objection to the improper venue only when said ground for objection became known to it. The court may not resolve the second motion to dismiss precisely because of the Omnibus Motion Rule, since the bank filed an earlier motion to dismiss but did not raise the ground on improper venue, and subsequently filed an answer wherein the improper venue has not again been raised. Hence, the question of improper venue has become moot and academic. The only grounds not barred by the Omnibus Rule are 1. Lack of jurisdiction over the subject matter, and B. It is litis pendentia, and C. Bar by prior judgment or by status of limitation. Suppose Therese did not raise the Omnibus Motion Rule. Can the judge proceed to resolve the motion to dismiss? Yes, the judge can proceed to resolve the motion to dismiss because the ground raised therefore became known to the movant only during the trial, such that it was only then that the objection became available to him. Suppose the judge correctly denied the second motion to dismiss and rendered judgment in favor of Therese, ordering the bank to pay her 100,000 pesos in damages plus legal interest. The judgment became final and executory in 2008. To date, Therese has not moved to execute the judgment. The bank is concerned that its liability will increase with the delay because of the interest on the judgment award. As counsel of the bank, what move should you take? As counsel of the bank, I shall recommend to the bank as judgment obligor to make a tender of payment to the judgment obligee and thereafter make a consignation of the amount due by filing an application therefor, placing the same at the disposal of the court which rendered the judgment. Articles 1256 and 1258 of the Civil Code. 2000. The RTC rendered judgment against ST, copy of which was received by his counsel on February 28, 2000. On March 10, 2000, ST True Counsel filed a motion for reconsideration of the decision with notice to the clerk of court submitting the motion for the consideration of the court. On March 15, 2000, realizing that the motion lacked a notice of hearing, ST's counsel filed a supplemental pleading. Was the motion for reconsideration filed within the reglementary period? Yes, because the last day of filing of motion for reconsideration was March 15, if February had 28 days, or March 16 if February had 28 days. Although the original motion for reconsideration was defective because it lacked a notice of hearing, the defect was cured on time by its filing on March 15 of a supplemental pleading, provided that motion was set for hearing and served on the adverse party at least 3 days before the date of hearing. Section 4, Rule 15. Alternative answer: since the supplemental pleading was not set for hearing, it did not cure the defect of the original motion. Rule 16. Motion to dismiss. 2014. Mr. Avenger filed with the original trial court a complaint against Ms. Bright for annulment of deed of sale and other documents. Ms. Bright filed a motion to dismiss the complaint on the ground of lack of cause of action. Mr. Avenger filed an opposition to the motion to dismiss, state and discuss the appropriate remedy or remedies under each of the following situations. A. If the RTC grants Ms. Bright's motion to dismiss and dismiss the complaint on the ground of lack of cause of action, what will be the remedy or remedies of Mr. Avenger? If the RTC grants Ms. Bright's motion to dismiss, the remedies of Mr. Avenger are: 1. File a motion for reconsideration under Rule 37. B. Refile the complaint. The dismissal does not bar the refiling of the case. Section 5, Rule 16. C. Appeal from the order of dismissal. The dismissal order is a final order as it completely disposes of the case, hence it is appealable. Letter D. File an amended complaint as a matter of right, curing the defects of lack of cause of action before the dismissal order becomes final. This is because motion to dismiss is not a responsive pleading. Hence, Mr. Avenger can amend the complaint as a matter of right. Section 2, Rule 10. Now B. If the RTC denies Mr. Bright's motion to dismiss, what will be her remedy or remedies? If the RTC denies Ms. Bright's motion to dismiss, her remedies are: A. File a motion for reconsideration. B. Proceed to trial, and if she loses, appeal and assign the failure to dismiss as a reversible error. C. File a special civil action for certiorari and or mandamus if the denial of the order to dismiss is made with grave abuse of discretion amounting to lack of or excess of jurisdiction. Letter C. If the RTC denies Ms. Bright's motion to dismiss and further proceedings, including trial on the merits, are conducted until the RTC renders a decision in favor of Mr. Avenger, what will be the remedy or remedies of Ms. Bright? If the RTC renders a decision in favor of Mr. Avenger, Ms. Bright's remedies are: A. File a motion for reconsideration or new trial under Rule 37. Letter B. File an appeal to the Court of Appeals under Rule 41. Letter C. File an appeal to the Supreme Court under Rule 45 if the appeal will raise only questions of law. Letter D. File a petition for relief from judgment under Rule 38. Letter E. File an action for annulment of judgment under Rule 47 on the ground of extrinsic fraud or lack of jurisdiction. All right, and this is the end of the bar Q&A remedial law sequenced in a syllabus manner, but I'd like to add an additional rules in the 2020 bar syllabus by attorney Esguerra. So we have 2018 revised internal rules of the Sandiganbayan. Coverage of the internal rules. The internal rules shall apply to the proceedings and internal operations of the Sandiganbayan, Rule 1, Section 2. Applicability of the rules of court and Supreme Court issuances. The rules of court, resolutions, circular, and other issuances promulgated by the Supreme Court, and so far as applicable, shall govern all actions and proceedings before the Sandiganbayan, Rule 1, Section 3. Next, the liberal construction of the internal rules. These rules shall be liberally construed to promote a just, expeditious, and inexpensive determination of every action and proceedings in the Sandiganbayan. The same rule. Organizational setup. The Sandiganbayan shall be composed of a presiding justice and 20 associate justices. Rule 2, Section 1, letter B. Rule on precedence. The presiding justice shall enjoy precedence over the other members of the Sandiganbayan in all official functions. The associate justices shall enjoy precedence according to the order of their appointments. Rule 2, Section 1, letter B. The rule on precedence shall apply in the seating arrangement, choice of office space, facilities and equipment, transportation and cottages. Rule 2, Section 1. The rule on precedence shall not be observed A. in social and other non-official functions, and B. to justify any variation in the assignment of cases, amount of compensation, allowance, or other forms of remunerations. That is in Rule 2, Section 1. The Sandiganbayan and Bank shall have exclusive control, direction, and supervision of all matters pertaining to the conduct of its affairs. The Sandiganbayan and Bank, for the exercises administrative, ceremonial, and non-adjudicatory function, Rule 3, Section 1 and 2, including 1. to promulgate rules or orders, amend, revise, or repeal existing rules or orders or parts thereof, and formulate and adopt policies relative to administrative matters such as the distribution of cases and the internal operation and management of the Sandiganbayan. Rule 3, Section 2. Has the control and supervision of the clerk of court. Rule 2, Section 6. Recommends to the Supreme Court from a list of qualified applicants appointments to the position of clerk of court, the division clerks of court, the assistant division clerks of court, and all other personnel to the Supreme Court. Study and recommend to the Supreme Court organizational matters. Section 3, Section 2 of Rule 3 submits to the Supreme Court for appropriate action all resignations, terminations of services, and disciplinary actions against officials and employees of the Sandiganbayan. Appoints the member of the Sandiganbayan standing committees on A. Gender responsiveness, B. Personal, C. Budget and finance, D. Security and safety, E. Records management and information service, justice officials and employee welfare incentive and benefits, legal and research services, building and grounds, acquisition, procurement, maintenance, and disposal of facilities, equipment and supplies, rules, raffles of cases, social affairs and liaison, ethics, special concerns. Those are under Rule 2, Section 8. Composition. The Sandiganbayan shall sit in 7 divisions of 3 justices each, including the presiding justice. The 7 divisions may sit at the same time. The presiding justice and each of the 6 most senior associate justices shall be the chairperson of a division. Each of the 7 most senior associate justices, next in rank, shall be the senior member of a division, and each of the last 7 associate justices shall be the junior member of a division. The Syndic shall exercise its adjudicatory powers, functions, and duties through its 7 divisions. The Syndic and Bank may request or recommend to the Supreme Court the creation of a special division to try cases where compelling reasons and the interest of justice so requires. Adjudicatory powers. The Syndic shall exercise its adjudicatory powers, functions, and duties through its 7 divisions. Rule 3, Section 1. The Syndic and Bank may request or recommend to the Supreme Court the creation of a special division to try cases where compelling reasons and the interests of justice so require. Section 3, Rule 3. Issuance of writs and process. Writs and processes of the Syndic such as warrants of arrest or search warrants, shall be issued by the chairperson of the division where the case was raffled, or in his or her absence, the most senior member present after having determined the existence of probable cause in accordance with the pertinent provisions of the rules of court. However, where there is an urgent necessity for the issuance thereof, before the case is raffled to a division, it shall be issued by the presiding justice, or in his or her absence by the most senior associate justice present. All other writs and processes shall be issued by the clerk of court or the division clerk of court upon order of the division. Electronic service and subpoenas and notices. In addition to the provisions of Rule 13 and 21 of the 1997 Rules of Civil Procedure, the Syndic may serve subpoenas and notices to parties, their counsels, and witnesses in criminal and civil cases through 1. Email, b. telephone call, landline or mobile phone, or c. by short message service or SMS. Rule 5, Section 3. In cases where there are detainees, such service shall be made through the officer having the management of the jail or penal institution where the inmates are detained. Rule 5, Section 3. Modes of service. Without prejudice to the provisions of Rule 13 and 21 of the 1997 Rules of Civil Procedure, the subpoena and notices shall first be electronically served through email or SMS. If these modes of service are not feasible, then the notices and subpoenas shall, with prior clearance from the justices, be served by telephone calls, either through landline or mobile phone. Rule 5, Section 7. Proof of electronic service. Printouts of sent email and acknowledgement by the recipient. Printout of SMS transmitted through the Syndic equipment or device and the acknowledgement by the recipient, or report of phone call made by the designated court personnel. Bail. Where a case involving a bailable offense has not been raffled to a division, the amount of bail shall be fixed and approved by the presiding justice, or in the latter's absence, the most senior justice present. Where a case has been raffled to a division, the amount of bail shall be fixed and approved by its chairperson, or in his or her absence, by any justice of the division, or in their absence, by any justice of the Syndic. Where the accused is arrested, detained, or otherwise placed in custody outside the National Capital Region, Sections 17 and 19, Rule 114 of the Revised Rules of Criminal Procedure shall apply. All bonds approved shall be without prejudice to the final action thereon by the division handling the case, which may either confirm the bond or require the posting of additional or different bond for the accused. Prohibited motions. The Syndic shall deny outright any of the following prohibited motions. 1. Motion for judicial determination of probable cause. B. Motion for preliminary investigation filed beyond the 5-day reglementary period in inquest proceedings under Section 6, Rule 112, or when preliminary investigation is required under Section 8, Rule 112, or allowed in inquest proceedings and the accused failed to participate in the preliminary investigation despite due notice. The Syndic shall deny outright any of the following prohibited motion. Letter C, motion for reinvestigation of the prosecutor recommending the filing of information once the information has been filed before the Syndic 1. If the motion is filed without prior leave of court. 2. When preliminary investigation is not required under Section 8, Rule 112. And 3. When the regular preliminary investigation is required, it has been actually conducted and the grounds relied upon in the motion are not meritorious, such as issues of credibility, admissibility of evidence, innocence of the accused, or lack of due process when the accused was actually notified, among others. The motion to quash information when the ground is not one of those stated in Section 3, Rule 1117. Motion for bill of particulars that does not conform to Section 9, Rule 1116. Motion to suspend arraignment based on grounds not stated under Section 11, Rule 116. And petition to suspend the criminal action on the ground of prejudicial question where no civil case has been filed pursuant to Section 7, Rule 111. Periods to comment and resolve meritorious motions. The comment of the adverse party shall be filed within a period of 10 calendar days from notice or receipt of the order of the Syndic to file the same. The Syndic shall resolve the motion within a period of 30 calendar days from the expiration of the 10-day period, with or without comment. At its discretion, the Syndic may set the motion for hearing within the period of 10 calendar days from the expiration of the 10-day period to file comment, and shall be resolved within a non-extendable period of 10 calendar days thereafter. Reply and memorandum shall not be allowed. Rulings on all written motions on interlocutory or incidental matters submitted to any regular division for resolution shall be reached in consultation among and by the unanimous vote of the 3 justices participating in the consideration thereof. Rulings on oral motions or objections made in the course of the trial or hearing shall be made by the chairperson of the division, provided that oral motions or objections on substantial but interlocutory or incidental matters may be ordered reduced into writing and shall likewise be resolved by the unanimous vote of the 3 justices of the division. In case of unanimous vote cannot be obtained, a special division of 5 justices shall be constituted pursuant to Section 1, Rule 9. A majority vote of such special division shall suffice to decide interlocutory or incidental motions. However, for cases arising from offenses committed after the effectivity of RA 10660, the concurrence of a majority of the members of the division shall be necessary to resolve such motions. Arraignment. Arraignment shall be conducted in accordance with Rule 116, Section 1 of the Revised Rules of Criminal Procedure. In handling division, may request in writing another division conducting hearings outside of its principal office to arraign an accused and resolve all incidents during the arraignment therein, and such arraignment and order issued relative thereto shall be valid and binding as if done by the handling division. Upon motion showing good cause thereof, or when the Syndic deems it appropriate, both the arraignment and the pre-trial of an accused may be conducted outside the principal office of the Syndic by the handling division upon request in writing by the latter, by another division conducting hearing in the locality. The accused may waive the reading of the information, provided that the Syndic is satisfied that the accused has full understanding of 1. The nature of and cause of the accusations contained in the information filed and as explained to accused by his or her counsel, and B. The consequences of the waiver. The waiver shall be reduced in writing and signed by the accused and his counsel, and shall be stated in the minutes or certificate of arraignment and the order of arraignment. Where an accused seeks to travel outside the Philippines prior to arraignment, the Sandigan Bayan in its discretion may arraign the accused under the following conditions. That if the information is not subsequently amended or refiled, the conditional arraignment shall be considered as the regular arraignment, and case may proceed even in the absence of the accused. That if the information be subsequently amended or refiled, the accused shall be deemed to have waived the right against double jeopardy, and the accused shall be arraigned under the amended or new information. That the accused will not lose the right under the rules to question in a motion to quash the amended or new information filed subsequent to the conditional arraignment, and that in a case the information be subsequently quashed or withdrawn, the arraignment shall be considered of no force and effect, and or shall be used as ground to invoke the right against double jeopardy. Hold Departure Order, or PHDO. A precautionary hold departure order, PHDO, under AM number 180705, dated 7 August 2018, is an order in writing issued by a court commanding the Bureau of Immigration to prevent any attempt by a person suspected of a crime to depart from the Philippines, which shall be issued ex parte in cases involving crimes where the minimum of the penalty prescribed by law is at least 6 years and 1 day, or when the offender is a foreigner, regardless of the imposable penalty. The division shall furnish the Bureau of Immigration with a duly certified copy of a hold departure order within 24 hours from issuance. Rule 8, Section 3. The application for a PHDO may be filed by the Office of the Ombudsman with the Sandigan Bayan. Upon motion by the complaint in a criminal complaint filed before the Office of the Ombudsman, and upon a preliminary determination of probable cause based on the complaints and attachments, the Office of the Ombudsman may file an application in the name of the people of the Philippines for a PHDO with the Sandigan Bayan. The application shall be accompanied by the complaint affidavit and its attachments, personal details, passport number, and a photograph of the respondent, if available. Determination of probable cause for the issuance of a PHDO. A PHDO shall not issue except upon determination by a division of the Sandigan Bayan, where the application is raffled that probable cause exists and there is a high probability that the respondent will depart from the Philippines to evade arrest and prosecution of crime against him or her. The division shall personally examine under oath or affirmation, in the form of searching questions and answers in writing, the applicant and the witnesses he or she may produce on facts personally known to them and attaching to their record their sworn statements. If the division finds that probable cause exists and there is a high probability that the respondent will depart, it shall issue the PHDO and direct the Bureau of Immigration to hold and prevent the departure of the respondent at any Philippine airport or ports. Otherwise, the division shall order the dismissal of the application. If the Ombudsman dismisses the criminal complaint for lack of probable cause, respondent may use the dismissal as a ground for the lifting of the PHDO with the Sandigan Bayan. If the Ombudsman finds probable cause and files the criminal information, the case with the division that issued the PHDO, on motion of the Office of the Ombudsman, shall be consolidated with the division where the criminal information is filed. The respondent may file a verified motion before the issuing division for the temporary lifting of PHDO on meritorious ground, that based on the complaint affidavit and the evidence that he or she will present, there is doubt that probable cause exists to issue the PHDO, or it is shown that he or she is not a flight risk, provided that the respondent posts the bond, provided further that the lifting of the PHDO is without prejudice to the resolution of the preliminary investigation against the respondent. Permission to travel. Respondent may ask the issuing division to allow him or her to leave the country upon posting of a bond in an amount to be determined by the Sandigan Bayan, subject to the conditions set forth in the order granting the temporary lifting of the PHDO. Suspension pendilite or preventive suspension. After the arraignment of an accused public officer against whom a valid information charging any of the violating or violations referred to in Section 13 of RA number 3019 is filed, the Sandigan Bayan shall motu proprio give the said accused a non-extendable period of 10 calendar days from notice, within which to explain in writing why he should not be preventively suspended. Thereafter, the Sandigan Bayan shall issue an order of preventive suspension of the accused, if found warranted, under the aforesaid provision of RA 3019 as well as applicable decisions of the Supreme Court. Preliminary conference and pretrial. The preliminary conference and pretrial conference shall be set at the time of the arraignment. Strict observance of the guidelines on preliminary conference is provided in AM number 03109 SC dated 13 July 2004 as amended by 150610 SC dated 25 April 2017 must be or shall be mandatory. Form of testimony of witnesses. The testimony of witnesses shall consist of the duly subscribed written statements given to law enforcement or peace officers, or the affidavits or counter-affidavits submitted before the office of the Ombudsman. If such are not available, testimonies shall be in the form of judicial affidavits in accordance with the Judicial Affidavit Rule. In all other cases where the culpability or the innocence of the accused is based on the testimonies of the alleged eyewitnesses, the testimonies of these witnesses shall be in oral form. Offer of evidence. As a rule, offer of evidence, as well as comments and or objections thereto, shall be made orally immediately after the party has finished the presentation of its evidence. However, upon oral motion and immediately after the party has presented its last witness, the Sandigan Bayan in the same proceedings may authorize the offerand the comments or objections thereto be made in writing. When there are voluminous and or numerous documents involved, the formal offer shall be made within a non-extendable period of 10 days from its grant, and the adverse party shall be given a non-extendable period of 10 calendar days from receipt of the said offer to comment or object thereto. Thereafter, the formal offer and the comment or objection shall be resolved within a non-extendable period of 10 calendar days, with or without comment or objection. Demur to evidence. The filing of a demur to evidence shall be governed by Section 23, Rule 119 of the Revised Rules of Criminal Procedure. The division shall resolve the demur within 45 calendar days from its submission. However, where a case involves several accused, and one or some of the accused did not file such demur, the demur may be resolved or decided simultaneously or jointly with the main decision after the presentation of evidence for the other accused for their orderly disposition of the case. Rendition of decision. Cases arising from acts prior to the effectivity of RA 10660. The unanimous vote of 3 justices in a division shall be necessary for the rendition of a judgment or final order. In the event a unanimous vote is not obtained, the presiding justice shall designate by raffle, on rotation basis, 2 justices from all the other members of the Sandigan Bayan to sit temporarily with them, forming a special division of 5 justices, and the vote of a majority of such special division shall be necessary for the rendition of a judgment or final order. Voting requirement for cases arising from offenses committed after the effectivity of RA 10660. The above notwithstanding, for cases arising from offenses after the effectivity of RA 10660, the concurrence of a majority of the members of the division shall be necessary to render judgment or final order. Motion for new trial or reconsideration must be filed within 15 calendar days from the promulgation of the judgment or from notice of the final order or judgment. The motion shall be decided within 30 calendar days from the date of submission for resolution. Grounds for new trial. A new trial may be granted in civil cases decided by the Sandigan Bayan in the exercise of its original jurisdiction on the grounds provided in Section 1, Rule 37 of the 1997 Rules of Civil Procedure. In civil cases appealed to or decided by the Sandigan Bayan, a new trial may be granted on the ground provided under Section 1 of Rule 53 of the 1997 Rules of Civil Procedure. A new trial may be granted in criminal cases decided by the Sandigan Bayan in the exercise of its original jurisdiction on the grounds provided in Section 2, Rule 121, or on the ground provided in Section 14, Rule 124 of the Revised Rules of Criminal Procedure in criminal cases appealed to or decided by the Sandigan Bayan. No motion for reconsideration or new trial shall be acted upon if the movant has filed a notice of appeal with the Sandigan Bayan or petition for review on certiorari or a motion for extension of time to file such petition with the Supreme Court. That is the effect of filing an appeal and petition for review on motion for new trial or reconsideration. The motion for reconsideration or a new trial pending with the Sandigan Bayan shall be deemed abandoned upon the filing of a petition or such motion for extension. Methods of review to the Supreme Court. The appeal to the Supreme Court in criminal cases decided by the Sandigan Bayan in the exercise of its original jurisdiction shall be by notice of appeal filed with the Sandigan Bayan and by serving a copy thereof upon the adverse party. The appeal to the Supreme Court in its appellate jurisdiction in criminal cases decided by the Sandigan Bayan and in civil cases shall be by petition, by review on certiorari under Rule 45 of the 1997 Rules of Civil Procedure. For automatic appeal, whenever the Sandigan Bayan in its exercise of its original jurisdiction imposes a death penalty, the records of the case together with a transcript of stenographic notes shall be forwarded within 5 days after the 15th day following the promulgation of the judgment or a notice of denial of a motion for new trial or reconsideration to the Supreme Court for automatic review and judgment. For ordinary appeal, appeal to the Sandigan Bayan from a decision rendered by a regional trial court in the exercise of its original jurisdiction shall be by ordinary appeal under Rules 41, 44 of the Rules of Civil Procedure, or Rules 122 and 124 of the Revised Rules of Criminal Procedure, as the case may be. Appeal to the Sandigan Bayan for a petition for review from a decision of the regional trial court in its appellate jurisdiction shall be by petition for review under Rule 42 of the 1997 Civil Procedure, Rule 12, Section 2. See you in the next upload. We'll pick up from here.